We're live.
Thank you. We will call the second case for this morning for the settings of the Seventh Court of Appeals on March 3rd, 2021. Before I do, though, I want to thank counsel for appearing through Zoom. Hopefully, things will be changing in the near future, given the governor's pronouncement yesterday of lifting some restrictions, and hopefully the Supreme Court will be following suit soon. But with that, we'll go on and call the second case, 07-20-00196-CV, Canadian River Municipal Authority versus Hayhook Ltd. Mr. Williams, I'm assuming you're ready since you're here. Is that correct?
Yes, Justice Quinn, I'm ready.
Okay. And Mr. Smithy, I presume you're ready too because you're on Zoom as well.
Yes, Your Honor.
Okay. With that then, Mr. Williams, you're first up.
Thank you, Justice Quinn. May it please the court. Your Honor, appellant is requesting that this court reverse and render the trial court's judgment in this case because the trial court did not have subject matter jurisdiction over the inverse condemnation claim. In order for Hayhook to recover under a takings claim, as this court is aware, the first element is that the state intentionally performed certain acts, and then those acts resulted in the taking of property.
Is there any question that, counsel, is there any question that the Canadian River Municipal Water Authority is considered the state for purposes of taking?
No, Your Honor. And in fact, this has been, this is the second appeal related to a jurisdictional issue. You authored an opinion in 2015 on a plea to the jurisdiction that Cromwell raised at that point as well. So the Texas Supreme Court has held that the state wears two hats, the state as a party to a contract, and then the state as a sovereign. And when the state is acting pursuant to a contract, it lacks the requisite intent to commit a constitutional taking. This case involves the construction of a water transmission line by Cromwell across the Hayhook Ranch, and that occurred in 2009 timeframe. Going back a couple of years in 2000, Cromwell had entered into a rather lengthy agreement concerning the installation of a water well field. I'll refer to that as the 2000 agreement. That was entered with the Campbells. Hayhook is a successor in interest to that agreement. In 2013, Hayhook brought suit against Cromwell, alleging that the construction of this pipeline both breached the 2000 agreement and asserted a claim for inverse condemnation. Now, at that time, Cromwell filed a plea to the jurisdiction. One of the issues raised was that the trial court lacked subject matter jurisdiction over the takings claim. That was never actually decided at that time by the trial court because Hayhook dismissed the inverse condemnation claim. The plea to the jurisdiction on the breach of contract claim went up to this court. Justice Quinn, you authored a well-reasoned opinion applying law.
Is that because you won?
Yes, and sent it back down to the trial court on the breach of contract case. After that, Hayhook re-injected the inverse condemnation claim. The parties went to trial. The trial court entered judgment on the inverse condemnation claim, and that was an error because Cromwell was acting pursuant to two agreements, 1976 water well field agreement and the 2000 agreement. I won't go into great detail about the agreement, other than to note the water well field agreement. That was a rather large transaction for $2.4 million for the water rights under the Hayhook. Part of that agreement provided, and it was SPS that entered that agreement, were the successor in interest, but access to water well sites and all easements reasonably necessary and desirable to develop the water rights.
The water rights they're referring to, are those the water rights obtained vis-a-vis the Hayhook, under Hayhook property?
Yes, Your Honor. Yes, Your Honor. And then fast forward to 2000, we have the 2000 agreement. There are various provisions of that contemplate the construction of additional pipelines, provide for the right to connect those pipelines to pipelines off the Hayhook, and it outlines a calculation of damages. At trial, Crimlaw presented extensive evidence that it was operating pursuant to those agreements. Kent Satterwhite, on behalf of Crimlaw, discussed the process of obtaining rights to build a pipeline, that Crimlaw does not begin construction before it obtains an agreement or condemns the property. If they're unable to reach an agreement, they condemn the property. Here, there was some communication prior to construction activities to try to get an amendment to the 2000 agreement. That fell through. Regardless, Crimlaw proceeded with construction because they believed that they had the right under both the water rights conveyance and the 2000 agreement.
If you had the rights under those documents, why get an amendment?
The testimony at trial, and this was undisputed, was that Crimlaw is partly in the landowner relation business. And if it pays one neighbor one thing and another neighbor another thing, it can cause some tension between landowners. And so if you were to calculate the damages owed under the formula of the 2000 agreement, Hayhook would have been receiving significantly less than the neighbors. And so for purposes of landowner relations, they were offering a calculation of just, I think it was $100 a rod or something along those lines to bring Hayhook's compensation in line with neighboring landowners. And also at trial, Mr. Campbell, a couple of acknowledgments. He indicated, I think they had the right to build it. I've never questioned whether they had the right to build it. After he noticed construction activity, he didn't indicate to Crimlaw that they were out there, they were trespassing. He just sent an email that said, please have your people notify me when you're on the property. In evidence is also Plaintiff's Exhibit 37, where Mr. Campbell, on behalf of Hayhook, indicates that he believes the damage calculation under the settlement agreement applies, and here's how you calculate damages. And so the parties proceeded pursuant to this 2000 settlement agreement. As I indicated, there was a previous appeal. In that appeal, Hayhook represented to this court, and I pulled a couple of quotes from their briefing, that the doctrine of governmental immunity does not apply here because Hayhook's claim arises from Crimlaw's breach of the settlement agreement, and Hayhook's claim is for breach of a contract for goods and services. And as I indicated, Justice Quinn, you issued an opinion saying that because we're dealing with a settlement agreement under loss and authority, we're going to send it back down.
Are you contending anything like that statement to stop them from changing the argument, or they judicially admitted that this is something other than takings claim?
Yeah, I mean, I think they have judicially admitted that this is a breach of contract claim.
Was that brought up in the trial court?
No, Your Honor. Okay. However, I think based on I think what the court could decide this just based on solely looking at the allegations made by Hayhook in their petition. In the petition, there's an acknowledgement of the contract. There's an assertion of a breach of contract claim under the 2000 agreement. It seeks damages under the 2000 agreement. At trial, the parties entered stipulations that would provide for the calculation of damages. This formula, let me back up. There's a formula in the 2000 agreement where you have to do a little math to come up with it. And the parties entered some stipulations for purposes of trial to avoid having to go through that math exercise. At trial, Hayhook requested the court enter judgment for a breach of contract claim in the alternative. So look at some of the case law on point. The first case really that I think addresses this point of the color of right doctrine is the Little Tex case, the Texas Supreme Court. And that was a consolidation of two cases. That's where the court said that, essentially the state wears two hats. And when you have your party to a contract hat on, you do not have the requisite intent to commit a constitutional taking. And I think this is important. Then Justice Abbott at the time, he wrote a concurring opinion. In his concurring opinion, he indicated he would add a requirement that there needs to be some additional finding that the state, had a good faith belief its actions were justified under the contract. The Texas Supreme Court has discussed this issue two more times, I think in 2007 and 2010. There's the State versus Holland case and the Kirby Lake case. And in neither of those cases did the Texas Supreme Court adopt this good faith requirement that Justice Abbott suggested at the time. And so that's why I think you can actually decide this based on Hayhook's claims in its petition and the acknowledgement of the existence of the contract.
Do those cases you mentioned or any other cases discuss the need for a relationship between the contract and the underlying dispute? Or can somebody just say, can the state just say, hey, this contract to purchase a car dealt with buying the airplane?
Well, there are a couple of cases. I think the State versus Holland may come pretty close to that scenario that you're discussing. There, the GLO was working on a pollution abatement. And the GLO contracted with two companies to provide services for a water processing facility. The plaintiff was actually a manager of one of those two companies. And the plaintiff built this filter system for the plants that was eventually adopted and placed in 3 filtration systems. After that, the plaintiff, in his individual capacity, he went and applied for a patent on this filter technology, and then turned around and looked at the state and said, well, hey, you owe me money for patent infringement royalties. And so the plaintiff's claim in that case was actually separate and outside of the contract with the two companies the GLO had contracted with. Irregardless, the state or the court in Holland said the absence of an express contract between Holland and the state or uncertainties about the existence of an implied contract between them are immaterial to determining the capacity in which the state is acting. And so really the focus should be, well, what did the state, were they acting pursuant to the contract? And so there needs to be some connection with the contract. But in the Holland case, the plaintiff wasn't even actually a party to the contract. I want to touch on a couple of things. The trial court did make a determination that the construction of this line fell outside of the scope of the 2000 agreement. The parties had interpretation disputes regarding whether this pipeline was allowed under the agreement. Trial court eventually determined that it was not. I don't think for purposes of whether the trial court had jurisdiction over the inverse condemnation claim, I don't think that's material. There's the Galveston Wharf case out of the Houston Court of Appeals in 2009. And that case mirrors what we have here, where the government had leased some property and over the course of a couple of years, I think, had gone back to the plaintiff and got amendments to the lease agreement to provide for the construction of additional pedestrian walkways is what was at issue. At one point, the government went back and said, hey, I want to build more pedestrian walkways. Plaintiff said no. Government went ahead and did the construction of the pedestrian walkways. The government said, well, I was acting pursuant to my rights under this lease agreement. Even though there had been an attempt to modify the agreement, so touching on the concern you raised earlier, in the Galveston Wharves case, they also tried to amend the agreement. The Court of Appeals in that case said, we do not decide which party's interpretation is correct to assess the trial court's subject matter jurisdiction over the suit. Even if the Wharves contract interpretation is incorrect, that would not change the capacity in which the government is acting. So the fact that the trial court here determined that the construction of this pipeline fell outside of the scope of the 2000 agreement, that's actually immaterial to whether the court had jurisdiction over the inverse condemnation claim. I did want to touch on some cases that Hayhook has raised, just to draw a distinction. They've raised a couple lines of cases for the argument that, well, we know that Crimois was intentionally building this pipeline. I mean, they had construction plans, they contacted landowners, and so that was an intentional act, and the intentional act of constructing the pipeline is enough to establish the takings claim. That is in reliance on a line of cases called that I've referred to as the Jennings cases. In those cases, and it's typically the same fact pattern, government engages in some act like building a culvert or a ditch or something along those lines, results in flooding a neighboring property, and there's a takings claim that is asserted. And so the Jennings line of cases has only been applied to involve circumstances in which the governmental entity's intentional act is not the actual physical taking of the property, but rather the cause of a physical taking. And that distinction is made in the Cope case that's been cited by both parties in their brief out of the Austin Court of Appeals, 2008. The other line of cases that I wanted.
Can I ask a question first before you run out of time? I think opposing counsel submitted an exhibit the other day. Did you get a copy of that? An exhibit?
Yes.
And I guess it's a map of the land in question and where the current pipe is. Is that correct?
Yes.
And is the current pipe the dark shaded one?
Hold on. I believe so. I believe the mark on the exhibit was the constructed pipeline.
Okay, and is 13A through 23 all Hayhook?
Justice Quinn, I have not been able to pull that up.
It's okay.
But I believe that is accurate.
Yeah, and I don't know if you can see that. Is there the pipeline that was built and that's underlying the suit here, is it connected to any wells, water wells on Hayhook property?
It is not connected to water wells on the Hayhook property. The pipeline runs from the pumping station on the Hayhook property to a neighboring property and connects the pumping station and the main pipeline to an off-site well field.
Okay. What under the contracts agreements that you've referred to, do you believe allowed the Canadian River Authority to argue that they had a contract right, they had the right to bury a line across Hayhook property that is not going to be used for draining water under Hayhook property?
And that focuses in on the actual interpretation argument that the.
I understand, but I want to know what you think.
So on page 21 of the 2000 agreement, there's the consideration paragraph, and it says that the consideration paid, and it was about $500,000, includes the right to connect, and I'm abbreviated some portions of this, but includes the right to connect those pipelines depicted on the plans, which it would include the main pipeline that runs from the pumping station. Okay, so the right to connect those pipelines depicted on the plans to pipelines located on property other than the water rights lands. Now, the interpretation issue at trial was whether that language meant that Crimwa could connect those pipelines, but that meant that that connection had to be offsite, or whether they could connect those pipelines and that connection could be on the Hayhook. And so that's the actual contractual interpretation issue. Judge Emmert decided against Crimwa on that point, but when Crimwa was constructing the pipeline, it was constructing it to connect the main pipeline to a water well field offsite. And so that's the specific provision that they were relying on. In addition, there's some language in the settlement agreement that provides Crimwa with the ability to construct additional transmission lines and outlines a formula for compensation for the construction of additional pipelines, and states that Crimwa has all easements or that Hayhook must provide Crimwa with all easements necessary for additional pipelines.
Thank you. You do have 5 minutes to vote.
Thank you, Your Honor.
Mr. Smithy?
Sorry, I was muted. May it please the court. Your Honor, first of all, let me say my video, I'm right on top of you, and I don't like that, but to get my sound where it's hearable, I'm on kind of a makeshift operation. I'm in Austin, so I apologize to the court, first of all, for that.
Are you saying Austin's a makeshift operation?
Well, my operation's makeshift.
Oh, okay.
But in this case, the threshold issue, as far as we were always concerned, was whether this was a contract action or a reverse condemnation action. You know, it didn't matter to us. We just knew they had built a 2.7 mile pipeline across our land, about 120 feet wide. We had a contract in place, and we didn't know whether it was covered by that contract at all. And the reason is you have to know specific things about the technical installation and the use of the pipeline to know whether it's covered under the contract. Well, and just the exhibit that the court referred to, let me just hold it up. This is really low tech, but this is what it is. This is what it is. And what you see here is this is land right here off to the east of the Hayhook. And this pipeline, what we call the phase 3 pipeline, it goes directly. It's an express route to bring water from off the Hayhook directly to pump station 21 that's on the Hayhook Ranch. That line, there was no easement for it by any agreement. And it also, it doesn't intersect or connect to any other pipeline. It doesn't, it just goes straight to a holding tank at the pumping station. So once that purpose came into evidence, once we found out what the purpose of the phase 3 pipeline was, the only purpose was to bring offsite water across the Hayhook Ranch. Well, if you go back to the 2000 agreement that Mr. Williams talked about, what you see is that that's one right that was expressly not granted by that agreement. They didn't have a contractual right. And so the trial court found, first by a partial summary judgment, that the original 1976 water rights conveyance did not grant this right. And that hasn't been complained of in the appeal. There's no mention of that when they filed this appeal. And then secondly, the 2000 settlement agreement, the trial court made specific fact findings that said that the facts that would trigger coverage under the 2000 agreement did not occur. For instance, this was not routing water through existing pipelines. It was a whole new pipeline. And secondly, there was no purpose here of connecting one pipeline off property to another pipeline on property. It just simply didn't happen. And so that's fact finding number 8 by the trial court. They never challenged that fact finding. So when we came into this court and filed our original brief, our view was that had been litigated. The court determined that there was no right for this construction and use under the contracts. And so we had no breach of contract action under the trial court's rulings. Then we were left with a reverse condemnation case. And so that's where we are now. Now, what they're saying, they're not saying, hey, we want to come, and they've never said since the inception of the project, we want to pay you under this contract. And frankly, to us, it didn't matter. Our compensation was actually good under the contract. And it would have been a lot cheaper to litigate that. We wouldn't have had to hire an appraiser. But once the trial court made that determination, we have no breach of contract action if the contract doesn't apply. And so what you've got here is a case where there's no contractual right. They took our property and now they built the pipeline, and they're not saying, hey, we want to pay under the contract. They're saying, we don't want to pay anything. We want to take your land and use your land. They've been using it for 10 years, and we don't want to pay any compensation. And that the problem with that is you've got Article 1, Section 18 of the Texas Constitution for adequate compensation, and you can't just ignore that. I mean, they can't just ignore it. They're a sovereign. They're under a constitutional duty to pay adequate compensation, and that's exactly what the court did.
Counsel, if I may ask, and I may have missed it, you may have said it, but I missed it. Can you explain to me why the trial court said there's no breach of contract cause of action?
Well, if the contract doesn't apply, then, in other words, if there's nothing in the contract that gives Cremwa the right to build this pipeline and provides compensation for it, then we don't have a contract to sue under at that point.
Was there nothing in the contract according to the trial court, because this was a pipeline used to drain off Hayhook property?
Yes, it was, and that was a right that was specifically never granted. We were in negotiating these bargains, we were very careful. Hayhook was very careful to say, we'll let you use all the pipes you need to get water off our property and to harvest the water rights that you paid for. But we don't want our land to be used under these agreements to build pipelines to transport water from offsite across our property. And they agreed to that.
Okay. And you've read, I'm sure, opposing counsel's cases about acting pursuant to a contract and how they wear the hat as a party to a contract. Why wouldn't that apply here, given that there's a contract in your view?
Well, just because there's a contract between the parties doesn't mean that our action is a contract action. And specifically, once a governmental entity exceeds the rights or the license that's granted by a contract, it's a takings case at that point. And a case in point is the Callaway versus Parks and Wildlife case. Now, that was a case where down in South Texas, Parks and Wildlife wanted to dig a canal across private property for fish migration. And so they reached an agreement for that. But there was an agreement that said that it would not be open to boating in that canal. Well, at some point, Parks and Wildlife decided they were required to open it up for boating. And so they removed the obstacles that had been built that kept boats out of there. When the landowner sued, the court in the Callaway case said that because you may have a contract action, but you've also got a takings claim because the governmental entity exceeded its license under the agreement. It took more than it was entitled to under the agreement. And that's the way it has to be. Now, here, they're not saying at all that they had a right under an agreement. They're just saying, well, we mistakenly thought we had that right under the agreement. Now, like I said, we had no idea that we were going to relitigate whether this was covered under a contract in this court. But based on their original brief, there was nothing in there that challenged the trial court's ruling. So we assumed that issue had been settled, and we were moving on to the issue of whether their mistaken belief that they may have had a contractual right would basically exempt them from the provisions of the adequate compensation clause. And that can't be the law. If it was, no governmental entity would ever have to pay damages for a takings case.
Are you suggesting that there should be an element regarding the mistake and whether or not it was a bona fide mistake, or are you suggesting some other viewpoint?
No, I think it just depends on whether the use that the state put was a use that was within an interpretation of, or was in the contract as a matter of law. If it is in the contract, that's basically a defense to a taking. They didn't take anything because they had a contractual right to it. Here, they had no contractual right, so they took this. So, you get back into the Supreme Court case that looked at this exact issue years ago, and basically came up with the concept that, look, that a public entity could take this position, they would never have to condemn property. They just said, oops, we thought we owned it, and so we don't have to pay you any money. And that's clearly not the law. CRMWA is not the first governmental entity that's tried to do this. It's been done in a number of cases, but no court has ever, no reported decision has ever allowed a governmental unit to take this position successfully. It's not the first time. The cases are unanimous that you can't just say, well, we made a mistake, we thought we had the right. So there's two things here. One is the legal issue of whether a mistake becomes an exemption to the adequate compensation clause, and clearly it doesn't. And the second is whether the trial court erred in finding that CRMWA had the requisite intent to take this property. And the intent that is required in the Little Tex, the intent that is required, as Little Tex case makes clear, is the intent to commit the act that resulted in the taking. And here there's no dispute. They don't dispute that they intentionally went out there, planned a pipeline, and dug a hole and put a pipeline in our property, and they've been using it 10 years. And so this isn't the color of title type case. This isn't where the state is withholding a performance under a contractual obligation. That's what Leach was about. The Leach case is one of the best explanations that came out of this court. It's not where the state is withholding performance under a contract. The trial court didn't give us contractual benefits at all that we had contracted for. Rather, what it did in this case is it just said, this isn't under the contract, so it's a takings claim, and it needs to be treated like a takings claim. The other thing I would say is that when we on the color of title issue, and one thing I would urge the court to do is to look at the Callaway case, which we cited. But it says that if the governmental entity exceeds its rights under a contract, to that extent, it has committed a taking. And that's clearly what happened in this case. One other thing I should mention, and that is going back to whether either of these agreements applied. I mean, the first thing is that the original water rights conveyance agreements back in '76, all it gave was the right to basically develop the water rights on the property. And this clearly had nothing to do with that. The 2000 settlement agreement said it says you can connect pipelines. Well, there's some dispute over what that means, but even if it means you can build a connecting pipeline, it expressly said you can't build it to bring water onto the property from outside the property. And secondly, this phase 3 pipeline didn't connect with any other pipeline. It went into a holding tank that went through a pump station and then ended up in the main pipeline, but the main pipeline isn't even depicted in the phase 1 plan. So it clearly doesn't meet the parameters of the 2000 settlement agreement. And so when the trial court found intent, it was making a fact finding that it had the right to make under the evidence that was before it. I mean, it's pretty clear that, I mean, when CRMWA comes in and says, hey, we just made a mistake, we thought we owned it. Well, that doesn't really comport with the evidence, because first of all, they provide us an amendment. And in the amendment, it says because the prior agreements don't cover the what we're doing in the phase 3 pipeline, we enter into this amendment. So they knew this. They knew it all along. And then we didn't, but they did. And so they know they know it doesn't apply. They put in the agreement, and they keep saying we're not paying you a penny until you agree to amend the prior agreements. Well, for them to come into court now and say, well, we all thought we already had that right to amend to run this pipeline without amending it is a little disingenuous. So there were a lot of other indications in the record where the trial court there was a fact issue here, and the trial court found it against Crimois, and that fact finding is not attacked in this court. So under the law, it's binding on this court. And so with the fact findings that are in place, it's clear that this is a takings claim.
Anything else, counsel?
I think that's it, Your Honor, if there's no more questions.
Judge Pirtle and Judge Parker, have any questions?
I don't have any questions.
Well, thank you very much. And Mr. Williams, you've got Judge Pirtle, you were on mute. Did you?
Yeah, I'm sorry, Brian. I'm good. Thank you.
Okay, thank you. Thank you, Mr. Smithy, and we'll go on over to Mr. Williams.
Thank you, Your Honor.
Thank you.
Your Honor, I want to first address the contention that Crimois' position has been, well, we were mistaken about our right to build this pipeline, and we don't want to pay you anything, but even though we were mistaken. That has not been Crimois' position throughout the entire litigation. I was actually in the unique position at closing to argue that Judge Emmert enter a judgment against Crimois for an amount as determined under the 2000 agreement. The issue, and Crimois has always taken the position that the 2000 agreement applied. We had a disagreement as to how do you calculate those damages under the 2000 agreement. My formula, netted something south of $50,000. Hayhook's formula netted something around $700,000. So Crimois has not taken the position that, oh, we were mistaken. Now, we disagree with the trial court's ruling regarding the applicability of the contract. We believe it applies, but we have not appealed that. The focus of our appeal is whether we were acting pursuant to the contract.
So right now, the trial court's decision that there's no breach of contract action because the contract doesn't apply, that stands. Nobody's appealed that.
Correct. That stands.
So if you're correct in your position, and that finding stands that there's no breach of contract action, then that means Hayhook gets nothing?
Correct.
So your client can build a pipeline across the land and not pay damages, doesn't have to pay anything, just gets free use of the land.
Hayhook would have had a remedy for a damage to property claim, not an inverse condemnation claim.
We're talking contract action. Wouldn't the remedy for damage to property be contractual?
Correct.
The court said there's no contract claim.
Correct. And so in that instance, if there is no contract claim and the government lacks the requisite intent to commit a constitutional taking, there is some case law that says that there could be a damage to property type claim. The issue with that is something that has to be raised within 2 years. And so this lawsuit was brought outside of that statute of limitations. So Hayhook was not without remedies, but unfortunately, just because of the posture of this and then the position they took that the contract didn't apply at trial, may end up resulting in not having any monetary compensation.
In your original argument, you indicated that there should be, quote, some connection, unquote, between the dispute and the contract, or the effort to do what your client was doing in the contract. Is some connection your words, or is that the buzzwords used by the court?
Those are just my words. If you look at the
And what do
determination,
you perceive some connection to be?
well, if we look at some of the case law, the government has to basically show, hey, we were acting pursuant to this contract. For example, in the Holland case, the plaintiff was not actually even a party to the contract, but the government said, you know, when I was engaged in this activity, I was engaged in it under the contract. And so because of that, I lack the requisite intent to commit a constitutional taking. The other case, Justice Quinn, did you have another question? Okay. The other case that I wanted to highlight, well, I want to talk briefly about the Callaway case. That case, there was an agreement to have this waterway closed, and the government decided that they did not, under the Constitution, have the ability to keep the waterway closed. And so you had a contract that said, we have to keep the waterway closed. And then you have the government acknowledging that we were acting outside of our contract, essentially, when we opened that because we didn't have the contractual right to do it. That's different from this case because we were always operating under our color of right under the contract. The other, well, I'll just highlight Texas Southern University case. In that case, it was unique because the government actually took the position at trial that the contract didn't apply and was still granted immunity because when they accepted the benefit at that time, they were acting under the color of contract.
Thank you, counsel, and your time has expired. Justice Purtle, Justice Parker, you have any questions?
Thank you. I'm good.
No questions.
Thank you. Counsel, we thank you for appearing through Zoom. Hopefully we will meet in person in the future in the courtroom. And the case is submitted and you are excused to leave. You guys be safe out there.
Thank you, Your Honor.
And we'll
Thank you,
be
Your
in
Honor.